I'm Gary Venner, CEO of IFA Acquisitions, and I'm joined by Gemma Irvine, who's the HR lead and director of HR People Support, who run trusted outsourced HR partner support, where we continue our informative question and answer series on our YouTube channel to provide insights into helping buyers and sellers understand the benefits of using HR specialists for the buying and selling of IFA businesses for sound HR advice. The title of the next video is coming up on the screen now. What's the downside if somebody, doesn't get that right? What liability would the outgoing or the incoming employer have?
So it's the incoming employer that takes on the liability and any potential claims relating to that. So the incoming employer really has to make sure that they've got all the advice necessary, and to be honest, that might just be HR advice, but it also, especially when you're looking at such a complex piece of legislation and you're looking at really kind of complex technical processes, you might need advice of an employment lawyer as well. They might be kind of as part of the process, and you might be able to kind of get them involved at different stages. But when it's very complex and very specific around these potential claims, it's really important to have that advice and support around you. These claims, they can be generally around kind of potentially unfair dismissal, but they also might be automatically unfair, and that can be around GP as well.
Yeah, and clearly that can run into thousands and possibly hundreds of thousands, I guess, in terms of compensation. So advice is clearly the right route, I think, to go through if it is complex and the potential redundancies are required. Absolutely,
yeah. And I think it's important to note that GP is complex. Every GP process has its own challenges, and it's not without risks. And it's kind of managing those risks and having the advice and support behind you to mitigate those as much as you can.
And sometimes I hear acquirers, particularly between a share purchase and an asset purchase. Well, I'm only purchasing the assets, so GP won't affect me. But that's not the case, is it? It does affect, even under an asset sale, where staff are involved.
Yeah, I mean, that's where the complexity lies in where GP applies and where it doesn't apply. In really simple terms, when you have an entity that is transferred, whether it's assets and people or clients, where it's transferred, GP will apply. But at that point, whether GP applies will be kind of assessed at the very beginning of the process, and it's at that point where you have the kind of the legal implications and the legal advice in terms of whether it applies.
And I'm guessing there, so if a business has staff and some move over, that's GP, that's to be concerned about that. Whereas maybe, let's just say there's a sole advisor firm with one administrator, and that's not going to be part of the move. It's an asset sale, so therefore I'm assuming because it's not forming part of that transfer, it wouldn't apply under GP. Is that right?
It really depends on the specifics of the actual transfer.
So you really need to sort of look at the case by case basis.
Absolutely, yeah.
Gemma, often when I'm dealing with acquisitions, we talk about staff contracts, and there are lots of different scenarios, and I'd just like to ask your expert opinion from HR point of view here. What happens when staff haven't actually got any employment contracts? What should they do in that situation?
I think it's a really difficult one, because obviously from a legal perspective, employees have a right to have those written particulars of employment. ideally there would be something, whether that's an offer letter, there would be something that has happened historically to create that binding agreement. If there isn't anything, I would be looking at what the implied terms are, so what the relationship is based on, so how much they get paid for how many hours they do, where they work, what kind of work they do, and really kind of come down to the basics of what that agreement is based on. Really that's all you can do, and it's looking at implied terms, it's looking at kind of working custom practices and how long that they've been going on for. If something is relatively new that's been introduced and you haven't been doing it for that long, there's not really the argument to say actually this is an implied contractual term.
Yeah.
However, and I'm going to use the example of kind of bonuses, annual bonuses, because they are highly contentious. If there is an annual bonus that's been happening for the last 10 years consistently and it's always happened, that's deemed an implied contractual term, and that will be part of what needs to be carried on and protected over the transfer.
So would there be a defence that, well, that was discretionary, and so each year it was made on a discretionary basis, or not?
The discretionary defence is very difficult when it happens consistently year on year. If it is really consistently, you have to demonstrate it's really discretionary, and that might be ad hoc and it changes, and it needs to be discretionary. That's what you rely on in that circumstance. But really you're kind of looking at the whole of the working relationship in order to factor all those implied terms and working practices in, but then as an incoming employer you then have the liability to ensure that there is a contract of employment in place, so you need to put that in place because you would be liable without anything in place.
Yeah, sure. And and I think from the protection of a business that haven't got any employment contracts in place, is that the staff, there is implied, isn't there, the statutory expectations of an employee, of how they conduct their work, etc. But clearly, to move forward, a contract needs to really be put together, and of course it just needs to sort of mirror exactly what is happening and what has been happening, I'm guessing, and to put those in there. If the business is looking to put in a certain covenant in their restrictive practices that weren't there because there's no contract there, then how can they do that with the agreement of staff?
So restrictive covenants is really difficult, and I think that's part of ensuring that you've got a really robust kind of ELI and due diligence process, and making sure that you have upfront the contracts of employment and the documentation in place for employees. So really you're looking at that checking mechanism right from the start, so there aren't any surprises as you get closer to the transfer date. But in terms of, in the absence of any restrictive covenants, really the only way is to put those in with agreement.
With agreement is the key.
Yeah, absolutely. Because there isn't anything that's in place previous that kind of has been, that you can bring forward. In the absence of anything, you're going to have to get them to agree to it. So it's very difficult in order to do that. It's very challenging and can be contentious, but the reality is that if you go through a correct consultation process and you talk through with them, and potentially you're offering enhanced terms and conditions over and above what they already have, then you're able to reach agreement.
Sure, yeah, and it's sort of that sort of pros and cons of the what's new and what's beneficial, I guess.
Absolutely.
Yeah, and am I right in thinking that if you were looking to add in something, it really ought to have some sort of consideration value as well? So maybe that for offering something new, something that in respect of that, then there will be an acceptance of a restrictive covenant.
Yeah, absolutely.